In North Carolina, we have a lot of residents that have moved here from another state, which means a common question that comes up is if I did my will or estate planning documents in another state, do I need to update them now that I've moved to North Carolina? Today, I'm going to share with you 4 reasons why you should have your plan reviewed and why it may need some updating if you've moved to North Carolina. The first thing you should know is that the laws vary from state to state. Each state has different rules about who's authorized to serve as your executor or power of attorney, how marital property is handled, or what constitutes a valid will in your state. So it's always a good idea to have your plan reviewed if you've moved here from another state and make sure that the plan still works under North Carolina law. Second, we do find that a lot of out-of-state wills need to be updated for North Carolina. We have this law that says that North Carolina will honor out-of-state wills if they meet certain requirements. The issue is that this puts the burden on your executor to prove that that out-of-state will meets the requirements. This might actually make more work for your executor in the long run versus just updating the document. Second, we find that North Carolina tends to have stricter requirements for what constitutes a valid will compared to many other states. And so we run the risk that that out-of-state document won't hold up when needed, or that it won't be honored for purposes of transferring real estate because the rules around real estate are more strict. So usually we find it's better and easier to just update the will than to take that chance that the out-of-state will might not be accepted down the road. Third, the requirements for healthcare directives and living wills vary dramatically from state to state. We always recommend that our clients have the state-specific North Carolina healthcare directives. If you're having some sort of healthcare emergency, we want to make sure that your medical providers, that they're focused on your medical care and they're not waiting on some opinion from the legal department about what your loved one's authorized to do on your behalf. Nobody wants to be in that situation. So we always think it's safer to have the state-specific North Carolina healthcare directives. But even if we put all those other reasons aside, here's the main reason why we recommend that you have North Carolina documents. Think about the reason you did your estate plan to begin with. It was probably because you wanted to make things easier for your family and avoid unnecessary stress or headaches. That's why we want you to have the North Carolina documents. We don't want your family stuck talking to local bankers or healthcare providers that don't know what to do with these out-of-state documents. And if your family ends up needing advice, we don't want them to have to hire 2 attorneys to get advice because otherwise that's what can happen. They might have to talk to an attorney from that other state to see what the document allows for, but then they might have to get an opinion from a North Carolina attorney about how that document gets interpreted under North Carolina law. So the bottom line here is if you want to make sure that your estate plan works as smoothly as possible for your family, you're always going to be best off to have North Carolina specific documents if you're a North Carolina resident. If you want true peace of mind that you and your family are protected, give our office a call and we'll take a look at your current documents and see what updates are needed now that you're a North Carolina resident.